January 31st, and we're going to have some additional testimony H118, starting with Paul. Over to you, Marshall. Thank you for being here.
Right. And let's see if I can successfully share the screen. Get in there. So, H118, let's just introduce myself, Marshall Paul, Deputy Defender General and Chief Juvenile Defender. And I'm talking today about H118, which is a bill to enlarge Vermont's hate crime sentencing enhancements. And I wanted to start off by talking about what is a hate crime sentencing enhancement, because I think there's often a lot of confusion about hate crime sentencing enhancements versus hate crimes. So a hate crime enhancement it's not a crime itself, it's a sentencing enhancement. And there's a reason for that, which is that hateful speech, hateful thoughts, hateful expressions are protected by the First Amendment. The First Amendment protects Americans' right to be racist, to be sexist, to have all kinds of really objectionable, horrible opinions, and to express those opinions. And that's unique to America. I mean, if you look, I saw recently an interview with a German prosecutor who was talking about Elon Musk and Elon Musk's gesture salute that he gave, and explaining how if he had done that in Germany, he would have been arrested, because that was, no matter what his intention was, it was a gesture that's associated with the German Nazi Party, and that is illegal in Germany. And that gesture alone would have been something you could be arrested and prosecuted for. We don't do that in the United States. In the United States, we have a very, very limited number of categories of speech that the government can actually regulate. So what is a hate crime enhancement? A hate crime enhancement, because you cannot prohibit somebody, for example, from using hateful speech, or from making hateful gestures, or from making hateful artwork. One thing that is permissible in a narrow set of circumstances is to say, when you commit another crime, but you commit it for a hateful reason, we can enhance the punishment on that crime. We can, if it was a crime that was punishable by 2 years, we can add extra years to your punishment because you had a hateful motive in committing that crime. So just for example, if somebody spray paints on the side of their neighbor's house because they don't like their neighbor's political beliefs, their neighbor has a Trump lawn sign or a Biden lawn sign, and they don't like that, and they go and they spray paint on the door, that's probably unlawful mischief, as long as the spray paint isn't terribly sticky and it costs less than $250 to get it removed. That's a 6 month. That's a 6 month penalty. That's a misdemeanor. If, on the other hand, you spray paint on the side of your neighbor's house, not because you disagree with their political beliefs, but because you disagree with their religious beliefs, then you could be prosecuted for the same offense, unlawful mischief, with the 6 month maximum, but you could also be prosecuted with the hate crimes enhancement because you were motivated by bias against their religion. And so that could add up to 2 years onto the penalty. So what would be a maximum 6 month misdemeanor, if you were doing it because you were motivated by political reasons, becomes a maximum 2 year and 6 month felony because you did it because you were motivated by religious reasons, by reasons of religious animus. So that obviously presents some risk because, as we said, the First Amendment protects speech, protects ideas, and generally speaking, prohibits courts from punishing people for their thoughts or their ideas or their expressions or their bias or their racism or their contempt. So the US Supreme Court has looked at cases involving hate crime sentencing enhancements and has sort of drawn some boundaries and said, okay, if you're going to do this, it has to be done within some very narrow boundaries. So there's a few cases that I think are really important to understand these proposed amendments to H118. And the first one is Dawson v. Delaware, and that's really the first time that the US Supreme Court grappled with this question. And that was a case where a defendant was charged with murder, and he was a white supremacist at the time of his trial. He was in a white supremacist gang. And the judge explicitly said, I'm giving you a higher sentence than I otherwise would have because you are in a white supremacist gang. The Supreme Court overturned that sentence and said, you can't do that because the white supremacy was not connected to his crime. In fact, the guy did not become a white supremacist until he went into prison after he had committed the murder. He was locked up for several years before his trial, and during that time, he became a member of a white supremacist gang. And so the judge said, no, the Supreme Court said, no, you can't enhance somebody's penalty just because they're racist. There has to be some connection to the victimization of the crime. So then there's a second case that comes up just 1 year later, and that's Barkley v. Florida. In that case, basically, a very similar thing happened. You had a group of people, one person in particular, who killed a guy. They were members of a group called the Black Liberation Army. They killed a white man, and the judge in that case did the same thing as the judge did in Dawson v. Delaware, said, because you did this in a very racist way, I am going to give you a higher sentence. That was challenged at the Supreme Court. People said, look, just last year in Dawson v. Delaware, you said you can't do that. But the US Supreme Court said, no, it's different in this case, because in this case, the fact that the defendant was racially motivated, that bore on his selection of a victim. He chose his victim because the victim was white. And therefore, all of a sudden, that racial motivation is relevant to the commission of the crime, and it can be considered in sentencing. So then we get to actual hate crime enhancement statutes. And the first thing, there's really two cases about hate crime enhancement statutes. RAV v. City of St. Paul and Wisconsin v. Mitchell. RAV is sort of the first one of these cases to come up. So the City of St. Paul creates a statute that prohibits the use of fighting words, which are already unprotected speech, if those fighting words were motivated to arouse anger, alarm, or resentment on the basis of race, color, creed, religion, or gender. Now, that seems like it should be something that would pass constitutional muster because it is limited to unprotected speech in the first place. But the Supreme Court said, even when you're limiting unprotected speech, you can't do it with any kind of viewpoint bias. So they said it's fine to prohibit all fighting words, but you can't prohibit just fighting words that are related to race, class, creed, gender, or religion, because that's viewpoint discrimination. That's allowing some fighting words, but not ones that are related to race, class, religion, etc. And so that, even when you're talking about unprotected speech or unprotected expressive conduct, any laws that restrict it still have to be viewpoint neutral. A good example of this is flag burning laws. So laws that prohibit the burning of the flag because it's a symbol of America and it is offensive and derogatory towards our country to burn the flag are prohibited because that has been considered a valid speech and a valid expression of speech. Laws that prohibit burning of the flag because they prohibit outdoor burning of anything are considered perfectly fine because it's not based on your viewpoint. It's based on the conduct. It's based on you can't burn a flag. You also can't burn a plain piece of cloth. You just can't burn things outside. And so even when you're talking about prohibited conduct, prohibited speech, any restrictions on it still have to be viewpoint neutral. Oops, I went one slide ahead. There we go. So then we get to, I think, the most relevant case, which is with Wisconsin v. Mitchell. Wisconsin v. Mitchell is sort of the model that the Supreme Court set up for, okay, RAV was where we told you how you can't do a hate crime sentencing enhancement. Wisconsin v. Mitchell is where the Supreme Court said, okay, here's how you can do it. So Wisconsin had a hate crime sentencing enhancement statute that said that any offense that you committed, the penalty could be enhanced if the reason for the enhancement was the defendant's discriminatory motive for selecting the victim. And I put the discriminatory motive for selecting the victim in italics because it comes up throughout the case. Throughout the case, that's what they say. This is what makes it okay. This is what makes it okay to enhance a penalty beyond the statutory range, is that the racism that's involved actually connects to the crime in terms of the selection of the victim. So because of the Wisconsin statute of Mitchell was focused on the conduct of selecting a victim on the basis of their race or ethnicity, not on the racist motive for the underlying offense, the Mitchell statute was upheld while the RAV statute was struck down. So where does that get us with H118? The proposed amendment to H118 makes section 1455 less like the constitutional hate-motivated crime statute in Mitchell and more like the unconstitutional hate-motivated crime statute in RAV. And specifically what does that is that the 118 removes the provision that was explicitly endorsed by the Supreme Court in Mitchell that connects the enhanced penalty to the discriminatory or biased selection of a victim. Instead, H118 does the opposite. It says the selection of the victim doesn't matter at all. What matters is the hateful conduct or the hateful expression that happens there. And so that, from our perspective, crosses the line into punishing people for their discriminatory thoughts, intents, biases, whether or not those thoughts, intentions, and biases had a connection to their actual selection of a victim or not. And that conflicts with the Mitchell decision and with our principle that we punish the intent and the action, but not the motive. While we're on the subject of 1455, I did just want to bring up another thing that has been sort of a persistent feature of 1455 in practice. 1455 is used on a pretty regular basis in Vermont. I've certainly had a number of cases with the hate crimes enhancement on it. And frankly, the penalty section does not make a lot of sense. And it's particularly true at the lower end. And what doesn't make sense is that it's a 2-year penalty enhancement on offenses that might have penalties as low as 6 months. So just to use the example again of damaging your neighbor's property, if you damage your neighbor's property because of their political identity, it's a 6-month misdemeanor. If you damage their property because of their religious identity, it's a 2-year and 6-month felony. So when you compare those two offenses and those two punishments, what you're talking about is really 6 months of punishment for the act and 2 years of punishment for the bias behind it. And from our perspective, that's incredibly disproportionate because as a principle of Western law, we steer away from punishing people for thoughts, biases, discrimination, racism, and we steer towards punishing their actions and their conduct. So our proposal would be that subsection A1, and so we're not addressing the more serious penalties, people who are committing hate-motivated crimes that are 5-year felonies. We're not touching those portions of it. We're looking more at the section A1 and section A2, which provide for 2-year penalties for offenses with underlying offenses with maximums as low as 6 months. And subsection 2, which provides for 5-year penalties for offenses with maximums as low as just more than a year. And so our suggestion would be to limit that so that we're never punishing people for their motivations more than we're punishing them for their actions. So that if someone is facing the hate crimes enhancement, that enhancement be limited if the penalty for the underlying offense is under a year, that the enhancement be limited to 6 months. And if the penalty for the underlying offense is between 1 and 5 years, that the enhancement be limited to 3 years and in no event more than half of the underlying sentence. And that's all I have. I'm happy to take questions.
Questions?
Go back slide.
Go ahead, Tom.
So under Mitchell, we go back to the people again, the swastika on the side. That's an inanimate object. There was nobody around, but it's an offensive painting, but it's not directed at anybody in particular at the time we're aware. But suppose there was some type of Jewish get together in the gazebo the next day, that would then
Fall under Mitchell.
that makes more sense.
And that's so that's also true. For example, if it was a swastika that was drawn, even if it wasn't around a gathering, but if it was drawn on a Jewish community center or on a synagogue or on Jewish gravestones, that would be targeted and therefore could fall under Mitchell. I forgot that I had one other slide. I did want to point out, I went through other jurisdictions because I wanted to see how other jurisdictions address this. And I didn't have time to go through all 50 states, but I did what I typically do when I'm doing sort of a limited survey, which is I looked at every state in New England. Connecticut has 5 different hate crime sentencing enhancements, but every one of them is focused on, did you target a particular victim on the basis of their race, ethnicity, gender, religion, etc. Maine has no hate crime sentencing enhancement, but it does have a statute that encourages judges to take bias motivation into account at sentencing, but they can't sentence above the maximum sentence because of it. They're just encouraged to consider it when they are sentencing within the range. Massachusetts has 2 separate hate crime enhancements, one for property crimes and one for assaults against people. And so there it's again, in both cases, focused on the selection of the victim. Most of these states mirror that language out of Mitchell. They choose, was the victim selected on the basis of bias towards their race, gender, religion, etc. New Hampshire has a hate crime sentencing enhancement if the defendant was, quote, substantially motivated to commit the crime because of hostility towards the victim's protected characteristic. New York has something similar, where the language is intentionally selecting a victim, at least substantially because of a belief or perception regarding a protected characteristic. And in Rhode Island, it's that they intentionally selected the person against whom the offense is committed because of the defendant's hatred or animus towards a protected characteristic of the victim. So again, each one of these states mirrors that language to some degree or another from Mitchell, which was upheld, and they steer away from the language that H118 is looking to adopt, which would sort of separate the selection of a victim from the hate crime sentencing enhancement.
Yeah.
So using the poor Brattleboro grandstand again,
Yes.
example. So I think the testimony that we heard previously on this was another issue was that the victim in the instance was the municipality because it's a municipal owned building or structure. So in the example that kind of was just used here, even if there was like a Jewish sort of like gathering at the grandstand, my understanding from the last testimony was the victim still is the municipality, and so you couldn't use the enhancement, even if the swastika was spray painted at the time or around when the. So I'm kind of curious, like
Part of that depends on how the prosecutor chooses to charge. And in that case, prosecutors chose to charge under unlawful mischief, which is the unlawful destruction of property. And when you charge under unlawful mischief, the victim is the owner of the property that was unlawfully destroyed. I think we have a statute in Vermont called domestic terrorism, which is anything where you target a group of people to instill fear in that group of people. If it had been charged under that, then the group of people who were targeted would be the victims of the offense. So some of this has to do with charging choices. If you choose to charge a property crime, the owner of that property is probably always going to be the victim of that crime.
Okay.
Thank you for this and sharing this perspective, because I feel like this is a new perspective that we haven't heard yet with this. A couple of questions with it. I'm curious in your review of states if you did come across any state that had it worded similarly to us, and you just didn't share that with us.
I did not, I did not, but I didn't go searching. I went straight to New England. I just went through the New England states, plus New York, since they're a next door neighbor, even though they're not New England. I include them. But that's my typical, if I don't have time to do it, which I usually don't have time to do a 50-state survey, these things, it's a lot of just doing these 5-6 states. Took me probably 2 hours on Westlaw last night. So that's why I select New England.
And so to clarify, what I'm hearing is how it is being proposed, the change so that that your thought that it could be challenged.
Yes, under Mitchell, Mitchell seems very much to tie the validity of a hate crime sentencing enhancement to the selection of a victim. And that's the language that they used in Mitchell, and then it's the language that's then been repeated in state statutes over and over again. And so from our perspective, when we remove the language where the person is being targeted because of that racial animus, you are diverging from Mitchell and falling more into RAB.
That's all. And I don't know, Chair, if you can just, I feel like this comes up in bills sometimes where we get conflicting opinions, and I feel like it's up to us as a committee to decide, but we have different perspectives. Ledge Council saying this is constitutional, and can you just help us navigate how we?
Yeah, and usually Ledge Council doesn't say like it's definitively
Yeah.
constitutional or not. They'll give us their best opinion and say ultimately the court is the final arbiter on that kind of question. But they will weigh in and say, yeah, we think it's likely constitutional, but they usually always hedge. But ultimately we do hear different opinions, and I'll just use last year as an example. Last year, or was it the year before, on a firearms bill that we had in here, and we had presentation from legislative counsel, from other people sharing their view, including from the Defender General's office. And Joe Andriano, Representative Andriano, thought it was unconstitutional, and I thought it was constitutional. So we had to make our own judgments. I prevailed at least on that one. I prevailed on getting the bill out of here. We'll see if I was right ultimately when this case is challenged.
All of us who thought it was constitutional prevailed.
Right. I mean, yes. So any event, so we'll have some additional viewpoints from a scholar on First Amendment law. I'm so happy that President Rodney Smolla is going to be able to testify after Marshall. Marshall's also, of course, a scholar because he frequently provides us information, just not as
I have
published.
not written First Amendment
I just hasn't written the First Amendment treatises yet. But I guess a question for you, Marshall, and a question, obviously, this is the fundamental question here. It's striking the term the victims, but how come an other person's it's not a victim or a group of particular persons? I mean, it's like,
And again, I would tie it back to the two cases that I talked about primarily. In RAV, they struck down the statute because they struck it down because it was not viewpoint neutral. when you turn to Mitchell, they upheld it because they upheld it because it was the identity of the victim that was the sort of locus of the sentencing enhancement. And every state that then adopted statutes to address this repeated that language, repeated the selection of the victim and identity of the victim as being crucial to the case. Now, there have not been that I've found cases sort of testing the boundaries of this since Mitchell.
Yeah, go ahead, Angela.
So, Marshall, looking at the bill as introduced on page 1, line 15, where it says, attempts to commit any crime whose conduct is motivated in whole or in part by, and then you have the new language. Is it what if it said whose selection of a victim is motivated by?
I think that would be constitutional.
Let's do that.
Good now.
So, yeah, it's curious. So would it be your contention that even without the change that our current statute could be unconstitutional?
I actually do think our current statute is questionable, and the Vermont Supreme Court has acknowledged that. There was a case, State v. Schenck, that was a case that involved two issues. It was a disorderly conduct charge with a hate crimes enhancement on it. And on appeal, the appellate attorney challenged both the sufficiency of the evidence for the disorderly conduct charge and challenged the hate crimes enhancement, and challenged it on its face, said that Vermont's hate crime statute, as it stands now, but not looking at 118, but just 1455 as it stands now, is too similar to the statute in RAV to be constitutional. And the Vermont Supreme Court didn't decide that issue because they decided that the guy had not committed the underlying offense of disorderly conduct, and therefore they didn't need to reach the issue of whether the Vermont's current hate crimes enhancement statute is unconstitutional. And they said they were reserving that for a later challenge, but there has been no later challenge. So that it's in and of itself is an up in the air question.
So if we say that if in fact the language focused more on the selection of a victim, then I think what our chair is saying, that couldn't then a group or another person's or a group of particular persons be the victim?
If they are the victim. And that changes everything. I mean, who the victim is changes everything in the circumstance. When the victim is a municipality, then somebody didn't select the victim on the basis of their gender, race. Perhaps they might have. If somebody crossed the border to Canada because they hate Francophone Quebecois and they spray painted something offensive on the side of then of course we're talking about Canadian law, not American law. So let's say somebody spray paints on the side of goes over to New York State, and there's some towns that are majority Amish and have incorporated a lot of Amish principles into their local ordinances and their local town practice. And let's say somebody spray paints something religiously hostile on the side of a town building there. That's possibly selecting a victim on the basis of the victim's religious preference.
Right.
I could see that falling into Mitchell, even though it's not a person
Yeah,
victim.
or even in the case of the Brattleboro gazebo, if you could prove that that it was like motivated by like there are just so many Jewish people living here.
That might be different. Or if the mayor of the town of Brattleboro was non-white and they selected to spray paint to deface the town of Brattleboro, particularly because of that. I think that might fit within Mitchell. So I don't think that there's no way to address this stuff. And I also want to make the point that this is a sentencing enhancement. It's not a crime. And so the fact that, we might look at somebody spray painting a swastika on was it a swastika they spray paint? I just assumed I hadn't actually read the article, but it's usually a swastika. Somebody spray painting a swastika on the Brattleboro gazebo, they're still subject to punishment. They're still subject to punishment for unlawful mischief. Honestly, I was a little tongue in cheek when I was using the misdemeanor unlawful mischief case before, because really misdemeanor unlawful mischief doesn't exist because of inflation. There's almost no property damage you can commit that's valued at less than $250 anymore. Even spray painting, like the bills for removing spray paint go well into the thousands for small spray painting things. But so that person is probably subject to at least a 1-year misdemeanor, if not a felony, depending on the value, the cost of remediating the damage that they did. So it's not as if we're talking about people getting away with anything here. We're just talking about when should we actually be punishing people greater than they are already allowed to be punished by law because of their bias or their hateful motivation in committing the offense.
Other questions for Marshall? Thank you very much, Marshall. I really appreciate it.
Thank you.
And share that with us. And President Small, if you could join us in the hot seat, although it's not really a hot seat, we're very friendly around here. And if you could identify yourself for the record and weigh in on H118. Appreciate you being here. Really appreciate
Chairman and members, it's my pleasure to be here. My name's Rod Smola, and I am the president of Vermont Law and Graduate School. I'm here in my private capacity as a scholar and a lawyer. I have been the author of 5 legal treatises that deal with constitutional law, including a number that deal with First Amendment law. And I've taught constitutional law and First Amendment law for 40 years. One of my current law students is here because we covered Wisconsin versus Mitchell yesterday, and we're going to do it. We're going to do it more this week. So I think I'll have a few quick opening remarks, and then I'll, of course, be very pleased to take your questions. I'm of the view that the existing statute is completely constitutional under the First Amendment, and that the expansions contemplated by the bill are constitutional. So let me begin by giving you my views as to what the significance of the Wisconsin versus Mitchell case is, and how it relates to the other famous landmark case that you just heard described, the RAV versus City of St. Paul case. So remember that in Mitchell, a group of guys were excited by having just seen the movie Mississippi Burning. They made the decision to engage in some violence against a white person. That's what they were saying to each other. An innocent person came down the street who was white. They attacked that person, beat him terribly. Wisconsin had a bias enhancement statute, and the conviction went to the Wisconsin Supreme Court, and the Wisconsin Supreme Court said, well, the U.S. Supreme Court has just decided this RAV case, and so this bias enhancement rule has got to be impermissible because what added to the penalty were the thoughts in the person's head, the racist thoughts of the attackers, and that turned this into essentially a thought crime, and that must violate the First Amendment. Went to the U.S. Supreme Court, and strikingly, in a 9-0 opinion, not a single dissent, the U.S. Supreme Court said, Wisconsin Supreme Court, you completely misunderstand what's going on here. And I'll go through it, not in great detail, but first, the court in Mitchell established the fundamental divide between the regulation of biased conduct and the regulation of speech that expresses bias. And very importantly for your purposes, the court made the point that our civil rights laws would be incoherent if we couldn't take into account the biased thoughts in the person's head when they commit the action. So as I said in the class yesterday, you can be a landlord and someone wants to rent one of your apartments, and you just don't like the person's looks, they seem scruffy, they seem shady, it doesn't, there's some vibe you're getting that you're nervous about, and say, I'm not going to rent to you. But if what's in your brain is because of the color of your skin, because of your religion, because of your age, that biased intent turns it into a violation of a Fair Housing Act. If you couldn't do that, you couldn't have civil rights laws. And the court then went on to say, we look at people's intent all the time. We look at the mental state. We do it in tort law and civil liability. We do it in criminal law all the time. And we calibrate the severity of the harm based on what's going on in a person's brain. And the court then says, and this is the key part of Mitchell, that when we talk about what's going on in your brain as being something that we take into account in the severity of the offense, take into account in sentencing, we don't just mean in a kind of antiseptic way, was it intentional, was it negligent? It can include the other violation, the other ideological reasons that you do it. And in a very key paragraph, it says, the state of Wisconsin could conclude that criminal activity undertaken because it has a biased motivation is more heinous than criminal activity that doesn't have a biased motivation. It's more likely to lead to civil disturbance. It's more likely to undercut the cohesiveness of the community. It's more evil. It's just a greater evil. And that legislative judgment that it's more evil is a perfectly permissible judgment for a polity to make, for a state to make. And then the court says, now, of course, it may be true that sometimes the way we know there was bias is because somebody said something. Speech is often the way you prove all sorts of criminal activity, antitrust violations, you name it. We often, if you're a criminal, you talk, and the things you talk may reveal what's going on in your brain. And in a very critical final passage in Wisconsin versus Mitchell, the court lays down the absolute rule: the evidentiary use of speech to prove an element of a crime or the sentencing severity of a crime does not violate the First Amendment. So with that backdrop, what's going on here? What's going on in the bill? It is not the regulation of expressive activity at all. There's an underlying crime that you must commit. All it does is elevate the penalties because of the motivation you had. So the question is, does anything turn on the magic words selection of the victim as opposed to the current wording, the person or group of persons, etc.? To my view, the answer is absolutely not. And one of the clues that it has to be absolutely not is to go back to the analogy to civil rights laws, where often the violation of a federal civil rights law is triggered by some sort of discrimination against a group. It may not even be a targeted individual. A simple example would be an employer can violate Title VII by using a test, and the test has bias in it. Nobody's even taken the test yet. They're not looking at a particular person. There's a systemic underlying racial animus that taints the law and can cause you to be in violation of a civil rights law. I heard a bit of the terrific testimony before me that I know is taking the opposite position. I wasn't here when the hypotheticals were being posed, but let's just take the example of a group of folks that are anti-Semitic and they hate Jews, and they say, let's go in the middle of the night and spray a swastika on the side of a synagogue. Nobody will be there. There's no human victim that we're targeting. It's a generalized animus toward Jewish people, and that's why we're going to deface this building. Well, that fits perfectly within the statute as worded. There's nothing in the First Amendment, in my view, that makes that an impermissible regulation of expression. The crime is the defacing, and society can make the judgment defacing out of religious prejudice is a worse offense than ordinary defacing. And I see nothing in Wisconsin versus Mitchell that transmits that into a violation of free speech. Remember that the RAV case was directly a regulation of speech, period. It said if you use a swastika, if you burn a cross in order to create, discomfort on a person based on their identity, you violate the St. Paul ordinance. It was purely an expressive regulation, whereas the Wisconsin versus Mitchell and Vermont statute are not. Last thing I'll say, and then I'll be quiet and take your questions. To me, nothing turns on that other expander in the bill. The other expander is that it need not be the sole intent or the predominant intent. It just has to be an intent. It has to be one of the animating purposes. And of course, prosecutors, as you heard, will have to use their judgment. Is there enough here that I think I could get a conviction beyond a reasonable doubt? That's always there as a safeguard. So the prosecutors might say, there may have been a hint of racism here, but I'm not feeling enough of it for me to invoke the statute here. But that's just ordinary criminal law, and very often the intent need not be the sole intent or the predominant intent. And I'll end by saying, again, in civil rights law cases, Title VII, Fair Housing Act, Age Discrimination Act cases at the federal level or the state level, quite often the liability is triggered when it's a mixed motive. The employer had some illicit motives, some non-illicit motives. You can still be held to violate the law, essentially parallel to this. So with that, I'll yield back to the chair for questions.
All right, questions, and I'm sure that there are questions. Because I'm sure I'll have questions if nobody else will, but go ahead, Angela.
Well, I'll ask the same question that I just asked, even, I know you said that the bill or the statute currently as written, in your opinion, is completely constitutional. But I'm wondering about the use of the word conduct, attempts or commit any crime, and whose conduct is motivated in whole or in part. So I just want to be very clear that you're okay with the use of the word conduct there, and that it's not, I don't want to say important, or maybe it's not preferred to instead say something like whose selection of a victim is motivated.
Right. And so the answer to your question is yes, exactly. You've got exactly my position right. It is true that the Wisconsin statute used the phrase selection of the victim, and some other states may do that, but that's not what the Supreme Court's decision turns on. And I brought with me the exact quote from RAV. Here's the sentence. Moreover, the Wisconsin statute singles out for enhancement bias-inspired conduct, because this conduct is thought to inflict greater harm. It's bias-inspired conduct. That holding doesn't say selection of the victim.
Barbara.
Thank you. That was super interesting. I'm wondering if you have any recommendations for us of how we can make the current bill stronger or better.
Well, I think the answer is I don't. That is to say that your expansions are relatively modest and incremental. One dealing with the level of intent, the other wanting to make sure that it's not hamstrung by a particular focused targeted victim. I think those are wise. Those are well within the constitutional bounds. I think they get the job done. The fact is, in most cases in which this would be used, there probably will be a targeted victim or targeted victims, so it really won't matter much. But I applaud the expansion. I think it strengthens the reach of the statute. It gives prosecutors more in their toolkits if they see this sort of thing. But I have nothing else to recommend beyond it.
Okay.
So I did have there's one question that's kind of out there as far as the language. On whether, I don't know if you have the.
I have the bill, I have it, yeah.
It's on first page, line 16. And I think it's on the second page as well, but it's whether we have to have the word particular in there, another person's or group of particular persons. Because there was some call to delete particular.
Yeah.
We believe in particular.
I don't think it changes the meaning. It might just be a little bit cleaner grammar. I don't think it changes the meaning. And obviously you've got the protected category list.
Right.
And so I think I'm agnostic as to whether you need particular or not, but I think you could axe it and it wouldn't change either the meaning of the statute or the constitutional analysis.
Yeah, okay. Because I think it's awkward having particular in there myself. But the other question I had is as far as with respect to the protected categories, a lot of these protected categories are, I think, fairly straightforward. I think we edged into crossing a line last time we looked at this when we put in the service in the U.S. Armed Forces or the National Guard. But there was a further consideration of whether we should put in law enforcement or public official or any other number of things. Do you have any viewpoint of how far one can go with the protected?
Right. And I don't think there's any constitutional constraint. I think it's a matter of prudence and public policy. So there are bias enhancement statutes. There are enhancement statutes if you attack a domestic partner. There are enhancement statutes if you attack a police officer. I think that's a public policy judgment. I don't think the Constitution restrains you. Now, if you were to pick and choose among races, of course, you'd violate the Equal Protection Clause. But I think you have the authority as a legislature to decide what protected classes you think are most deserving of this, and that's up to you.
Okay, I appreciate that. Other questions regarding the bill, because I have a broader question that I'm going to, once I jump in the bill, and since I have you in the seat, but any other questions regarding H 118? And I don't see any. So my broader question, since we have you here, and since we have a new federal administration, and there seem to be some concerning things coming from BC. Are there any things that you think we need to be watching out for as a legislator in the state related to perhaps restrictions on First Amendment law that we might be seeing?
So the two places right now where the action is, one involves regulation of social media. The other involves the use of funding to restrict expression in certain areas. And so the Supreme Court in the last 3 or 4 years, particularly the last 2 years, has rendered a number of decisions that are beginning to give the regulation of social media some contours. One directly impacts you as public officials. When you are engaged in state action that could conceivably violate the Constitution, including the First Amendment, when you use your own social media accounts, you use your own Facebook account or your own X account. And the Supreme Court in a case called Linke versus Freed last summer said, if you censor somebody on your private Facebook page and you're a government official, you're the mayor, you're a member of the state legislature, and you're acting pursuant to the authority the state has given you, and then you're subjectively choosing to exercise that authority, then you become a state actor and you could violate the First Amendment. But if you're not, if you're commenting on something outside your portfolio, so you're the head of prisons and you're commenting on a farm, thing, then there's no state action. Then you're a private figure. So that's important. That there's a lot of crisscrossing efforts to regulate social media companies. In a big case last summer called the Net Choice case, the Supreme Court effectively struck down efforts to force social media companies to avoid the moderation of content. So the narrative that was out there is that these companies were biased toward progressive speech and against conservative speech, and so they wanted to prevent them from taking down content. And the Supreme Court said, no, if you're Facebook, if you're X, you are a First Amendment speaker, just like the New York Times or Fox News, and you have a right to decide what you want to do with your moderation. And it violates the First Amendment to say you can't do it. So that was an important development. And then just a couple of weeks ago, the Supreme Court decided the TikTok case, complicated case, fairly unique because of the control of TikTok by ByteDance, which is a wholly owned a company subject to Chinese law and had been designated a foreign adversary. That arena has a lot of action. You may decide you want to do things involving regulation of social media at some point to protect children or for this or that reason. If you ever do, invite me back. I'll do the best I can to tell you what I think and sort it out. It can be complicated. But here's the other one, and I think this is probably more directly responsive to your question. And unfortunately, I'm not positive what the Vermont legislature could do, but at least we have it on the radar screen. Here's what we know is going on. The current federal administration is antagonistic to a lot of viewpoints that are at large in American society, particularly things that advance diversity, equity, and inclusion, the rights of transgender persons, LGBTQ plus rights. This administration is openly and unabashedly hostile to that expression, and has, of course, ordered the federal government to cleanse itself of all of that expression, ordered every federal agency that has DEI programming, for example, to immediately cease it. But the next steps down the road could be to say any recipient of federal funding is prohibited from engaging in this expression. And in the pause that was so chaotic this week, the pause on federal funding, which resulted in two major lawsuits. One, the state of Vermont was one of the 22 states that filed in Rhode Island. The other, a group of nonprofits, and others that filed in the District of Columbia. In the DC case, there was at the center of that case a First Amendment claim. The claim that Vermont brought doesn't have any First Amendment claim. It's an Administrative Procedure Act claim, a separation of powers claim. Does the president have the impoundment power? Was this procedurally permissible? But the other one does. And the theory of the DC case is you're using the leverage of funding us to dictate what we can say and not say. And many of us do have views on diversity, equity, and inclusion. It's part of our ethos. It's part of what we advance. And that violates the First Amendment. Now, that is a complex body of law. It's one of the most confusing areas of First Amendment law, but I think I can distill it in 60 seconds. There's two rules, and they are in tension. Chief Justice Roberts wrote the opinion trying to harmonize this. And he said, this is what you can do. You can shape the contours of a spending program by deciding you'll subsidize this activity, but you won't subsidize that activity. And the recipient can either give up the money and then speak and say what they want, or they can accept the money with the strings attached. But here's what you can't do. You can't use the fact that you're giving out money as leverage to manipulate speech outside the contours of what you want to subsidize or not subsidize. Now, Chief Justice Roberts said, I know that's confusing. He actually said this. I know this is hard because you can take almost anything and characterize it either way. But here's a simple example, and I'll be quiet. If a state agency in Vermont, if a private actor in Vermont is getting federal money, and that federal money is going directly to that entity's DEI programming, the federal government can turn off the spigot, say, we choose not to fund that anymore. But let's say the Vermont Law and Graduate School is getting federal money, which we do, to support things that are for agriculture or animals or things like that. My view is that the current law clearly is you can't say, if we give you this money for the agriculture program, that your student affairs office can't have diversity, equity, and inclusion program. That is leveraging the money beyond the subsidy decision to manipulate the free speech choices of private speakers. And there are Supreme Court cases that hold that. The most important, and I'll stop here, a case called Velasquez Legal Services Corporation. Congress was giving money to legal services for, the representation of poor people. It then said, you lawyers that bring these cases can't bring systemic challenges to institutions in society. You can't say the prison system is biased. You can't say the system, is biased. You can't do that kind of stuff. And the Supreme Court struck that down. and said, you know, the purpose of the program is to give money to poor people, you can't use that as leverage to manipulate the choices of lawyers and their expression and their clients' expression. So with that,
Great.
I'll hold back.
No, thank you. It's very interesting. So very helpful. Yeah, Barbara, go.
That is super interesting, and I've mostly been in the nonprofit sector and received federal grants, and many times those have come with incredible strings. And I was thinking about most of them fall in the category that you said that they can do.
Yeah,
You cannot give people abortion as an option.
that's one of the famous cases, right?
Yes.
Right.
But I'm wondering, there are always these other conditions, these general ones, including the Hatch Act,
Mhm.
which
Sure.
sort of feels like it is a veiled way of,
Well, yeah, I mean, you're getting into deep, dense stuff and it's complicated, it's difficult. I think the cleanest way to say it is when the condition is so blatantly viewpoint discriminatory, and when the condition seems to be disconnected from the mission of the nonprofit, gratuitously adding on to squelch this speech, then it's going to be vulnerable. And it's quite possible we'll see some of that.
Andrew.
So, gosh, I don't want you to stop talking.
Well,
I want to hear all of it, but, I'll ask a specific and very general question, but, how do you see this playing out in public education? And I think I understand what you're saying about, you know, let's say even more specifically within public education, special education, because that's where
Sure.
Vermont public schools, we get a lot of, you know, IDEA A, B,
Right.
one, you know, like all the grants are federal grants that fund
Right.
special education.
Right.
And there are, you know, all kinds of
Sure.
things under that umbrella.
Right. Sure.
I know that there are school districts really, you know, educators really worried right now
Yeah.
that what's going to be cut or what they will be disallowed, or, you know, not
Yeah.
allowed to do anymore
Yeah.
for kids.
So, I mean, it's a very general question and you'd have to know exactly what was attempted, but let me give you a clean answer. If what we were to see come down the road is any recipient of money supporting education, universities, school districts at the state level, any recipient of federal money may not include instructions on systemic racism, let's say. Anything that seems to promote the dignity of a transgender person. That if you're getting this money, drop that from your textbooks, drop that from your classes. In my view, that would violate the First Amendment. It would violate principles of federalism, you know, that the state is entitled to make its own decisions on these issues and would be vulnerable. Obviously, no prudent lawyer ever says, I'm sure you're going to win.
Yeah.
Laws in flux. We're in a very fluid period, but I think existing principles would say that crosses the line and you cannot do that.
Okay, that's what I'm just looking at this. The California Department of Education has said it is against federal law for the White House to dictate what educators can and cannot teach by threatening to defund essential public services.
Exactly my position. And just a quick footnote, even within those states that have done this with aggressively, like Florida really has done this for the Florida State universities, and for the federal courts have struck that down, even internal to Florida. And so who knows where that will go eventually. But there's a very eloquent federal district court opinion arising from Florida that says Florida can't use the fact that it funds these schools to say to teachers in the school, you gotta issue the Florida party line on the Civil War, and you can't introduce, you know, other views about that. So even within a state, there's some First Amendment vulnerability potentially. But I totally agree with what the California statement said.
Thank you.
Other questions? So just I'm not going to have you weigh into this, but I'm just curious. I've on the First Amendment, the other parts of the First Amendment, the separation of church and state, establishment clause, and such. Is that an area down the road we may be having to deal with that?
There's been a complete remaking of the religion clause.
Is that something we could call upon you to help us understand?
Absolutely.
If we get there? Yeah.
Absolutely.
Asking for that.
No, absolutely. And part of that remaking of the of Establishment Clause jurisprudence is the interplay between state constitutional guarantees and state laws and federal laws, and when one trumps the other. And you can call me anytime on constitutional law issues. It's my honor to be of help if I can be of help.
And maybe we'll just come and sit in on some of your
That
classes.
works. Yeah, that works. All right.
Appreciate it.
I appreciate it very much. Thank you all. Really enjoyed it.
Thank you so much.
Okay, my pleasure.